starts these things with us, but let me remind you of one other thing, which is that the handouts, which you usually got at when we were there in person, were sent to you by email early this morning, about 9:25. Susie sent it to you by email, and so if you want to look at the handouts as we go along, be sure to check your emails. This is, I should say, the first time I've engaged in a virtual CLE presentation.
Yeah.
Now, Brad
leave alone,
is actually
so,
already.
yeah. I have a 12 o'clock that I need to go to here, but I will look at that BMI and make sure that you can do it by chat.
Could you mute your screen? Thank you. So, as I was saying, this is my first virtual CLE presentation. Brad has done one with the ITLA, and he's very familiar with technology. But we're going to try to present this in an interesting way and hopefully have some information that will be worthwhile for each of you. As usual, in these presentations, I start with something I saw in the news that I thought might be of interest. And of course, what we've all been watching for the last several months is mostly about the coronavirus pandemic. And I thought I'd check to see, well, how has it affected our profession more generally? And I checked the ABA journal.com and observed that on March 17th, that shortly after this pandemic arose, the ABA journal was reporting with a headline, "The High Demand for Lawyers Amid the Coronavirus Pandemic," suggesting that it was going to create lots of work for lawyers, and that would be the major consequence. I believe this Kent Schmidt with Dorsey and Whitney commented, "Long after this health crisis is over, courts are grappling with untold numbers of litigation disputes concerning parties are excused from performance of their contractual obligations during this health crisis." So starts with the idea there's going to be plenty of work for lawyers and in the industry overall, and then 7 weeks later, there's this headline you now see on the screen of legal services sector shed a whopping 64,000 jobs in April. And that means that in March, we had 1,161,000, and by April, it was down to 1,097,000 in our sector. This, if you want a base of comparison, what was lost in 1 month in terms of the legal services sector, compared close to the 2-year losses during the Great Recession in 2007. And then you have the most recent one from last week. Law firm revenue takes a nosedive during COVID-19. New firm shows 81% of law firms have seen revenues. 27% of firms said business had declined by more than half. And Clio had reported there was a 40% drop in the number of new legal matters being opened each week in the U.S. Let me just remind everybody to your audio so that we can keep the focus on our presentations. Thank you. So you have a whopping reduction in jobs, a nosedive in revenues, and a statement that COVID has disrupted everybody, including the legal profession. We're all in uncharted waters here. So it's obviously something new and significant for all of us, but in terms of uncharted waters, the courts have been continuing to write opinions and make decisions.
I was counting on you because
we have a number of interesting cases to discuss with you. We're going to start with 4 cases from the Indiana Supreme Court. 2 of them I will be discussing, and the first one of interest is Estabrook versus Mazak Corporation, decided on March 2nd in an opinion by Justice Slaughter. And the issue before the court is actually stated there on page 3 because it was a certified question from a federal district court to the Indiana Supreme Court dealing with the statute of repose for products liability claims. And the question specifically was, can the statute of repose, codified in Indiana Code Section 3420-3-1B, be extended by post-sale repair, refurbishment, reconstruction of the product? And if so, what is the appropriate test to be used to determine whether the seller has done sufficient work to trigger the extension? So that's the question. You've got a statute of repose that basically says, as you've got it actually in the next section there, it says a product liability action must be commenced, one, within 2 years after the cause of action accrues, or within 10 years after the delivery of the product to the initial user or customer. And so when you look at that statute, within 10 years after the delivery of the product to the initial user or customer, Mr. Estabrook was injured in 2014 in connection with a machine that was manufactured and placed in service at Mazak in 2003, 11 years before 11 years after the product was delivered to the initial user. So it would seem to fall within the language of the statute of repose. But there were significant repairs and changes to the product. And Mr. Estabrook argued that because of the repairs, the statute of repose should be restarted anew, given the changes in the product. The Supreme Court considered this question, and in doing so, they looked again first at the direct language of the statute. And you will notice, as I read it to you a moment ago, it says, must be commenced within 2 years after the cause of action accrues, or within 10 years after delivery of the product to the initial user. So this case was filed within 2 years after the cause of action accrued, after he was injured, but not within 10 years of the delivery to the initial user if you're going to regard the product that was installed in 2003 as the same one after the repair. So the court is then confronted, obviously, with this word or, the disjunctive. It's either. And obviously, it qualifies under the first, but not under the second. So the question is, so why isn't this okay? And the answer is, that's not what was ever intended with that statute. And the court employs what it calls the absurdity doctrine, to be used when no reasonable person could have intended this result, and a judicial remedy is easy. So they could easily say, well, they meant and when they said or, and we're going to interpret it as and. And that's what the court does. It looks at the text of the statute, says, well, we're not going to follow the text. We're going to recognize that was never intended. It was an obvious mistake, and we'll proceed accordingly. So having looked, not being constrained by the text on that issue, the court looks at this, the issue of whether if you change the product, if you refurbish it or repair it, whether that starts it anew. And the court said, well, that's not there. Look in the text, you'll see nothing that allows for that exception. And because of that, the court declines to extend it to any product that has been modified or refurbished. In explaining that decision, the court, I think, interestingly, Justice Slaughter, as I phrase it in the middle of page 5, waxed philosophically by talking about an ancient, still unsolved riddle of metaphysics, which Plutarch made famous with his ship of Theseus paradox. Now, for those of you who may have forgotten it, who may not remember all your metaphysics and may not even remember what metaphysics is, it's laid out for you by Justice Slaughter in his opinion and by me. The question that Plutarch put, that is this unsolved riddle of metaphysics, was in this context. Theseus sails back from Crete, docks his ship in an Athenian port. Over time, the Athenians determined to preserve the ship, replace the board after it's rotted, replace them all, actually, until they finally replace the final one. Then Plutarch asked, is this a new ship? Essentially the same question under the statute of repose. Is this an initial user or customer of a new product? And the answer of a pupil saying, got all new boards, is answered yes. And Plutarch then follows up by posing the difficult line drawing question of, with which board did the ship become new? And Justice Slaughter then explains, this is a line drawing question that Plutarch says can't really be answered. It's a line drawing question. We're not going to get into a modification, even if every board is changed, is not going to restart the statute of repose. And so it's going to be enforced, and it will not be affected by any repair or refurbishment or modification. So that's the first lesson today from our Indiana Supreme Court, a lesson that they derive in part from Plutarch. But let's go to our next one, the case of Blair versus EMC Mortgage LLC, which again involves an issue of whether a claim is filed timely, not because of a problem with the statute of repose, but because of a problem with the statute of limitations. And when you see the factual wonder, well, how can the statute of limitations not have been offended in a case where the plaintiffs here, the Blairs, have entered into a 15-year mortgage in 1992. In June of 95, 3 years later, they make their last payment on the note. So to the extent there's a breach of this contract, it occurs first on June 1995, or the last payment's 95, and they never make any more payments on it thereafter. And then 17 years later, on July 3, 2012, they get sued on that note. And the issue is, well, has the statute of limitations run? So they breach it in June of 95. It's now 2012. There's no 17-year statute of limitations around here. Is it timely filed? And there have, in fact, been some Court of Appeals cases that address very similar, or in one case, a virtually identical issue, and basically say, we're gonna enforce the 6-year statute of limitations that generally applies in these situations, and allow a recovery at most of 6 years. But when the Supreme Court looks at this and they say, look, these Court of Appeals cases that have addressed similar issues, the first one involved what the court refers to as an open account, a credit card. And in that case, with an open account, kind of the last charge and the last when it's due starts the running of the statute of limitations. But this is a closed one. A mortgage is a closed account. There was an obligation assumed in June of 95 that continued until the note matured on January 1, 2008. And the lender could have foreclosed earlier. It chose not to. But it has essentially 6 years from when the note matured to file a lawsuit, and it has a right to the entire amount owed over the prior period of the note. That's what the Supreme Court determines, but in this case, the lender didn't really ask for that. They had simply sued for a missed payment within 6 years of a borrower's default. And that's all they wanted to seek, and that's all they got in the trial court. And the Supreme Court said, although they could have asked for and they could have gotten the full amount, given what they asked for, that's the limit of their recovery in this case. By the way, there was one other comment in the Estabrook case, which I had noted on page 4. Justice Slaughter had said, we alone are the final arbiter of Indiana law and owe no deference to the interpretations of Indiana law pronounced by other courts. We are the final arbiter and owe no deference. I guess we all knew that, but he says it right out front. And so that's obviously something one should keep in mind and keep alert to. Here, when this case got filed, the Blair case, there's 2 Court of Appeals decisions to the contrary. The Supreme Court is basically, it does set aside those cases as saying not correctly decided, and then proceeds to say you're entitled to a lot more. And I guess in terms of lessons from this case, you have on the screen the ones that arise directly from this issue of closed accounts and open accounts in terms of the statute of limitations being 6 years. One, as to credit cards after the borrower first defaults, as to the mortgage after the balance is due if the loan is not accelerated, so at the end of the term. What the court clearly holds here is it will not create a rule forcing lenders on closed accounts to bring an action within a reasonable time after default. And the further lesson that I would suggest to you out of this case is that if you're looking at Indiana law and there's only Court of Appeals cases on it, and you've got a good argument that that should be changed, and the Supreme Court, particularly as currently constituted, might be inclined to change it, you might take a more aggressive posture than the lender did in this case. And I understand the lender may well have had other reasons to take a more a less aggressive approach, but it's clear that the Supreme Court is prepared to take its own look at every issue. With that, I'll turn it over to Brad.
The first case I'm going to talk about is Collins Asset Group versus Ali. And it's a companion case to Blair, and the substantive issues in it are basically the same, and so they're not really worth discussing. But I thought this was really interesting because of the court's discussion of waiver and when it thinks a waiver is happening. So in this case, you had Ali got a mortgage in 2007, defaulted in 2008, but then the bank didn't accelerate until 2016 when it filed suit. And so he moved to dismiss, arguing it was barred by the 6-year statute of limitations, and the trial court granted the motion. Court of Appeals affirmed, and based on, among other things, that the bank had waived its argument about the statute of limitations that the Supreme Court found applicable in Blair. And on transfer, the court addressed that question. And it said that this is how it described the law on waiver, which I have in the handout on page 7. It said that the rule of the parties will be held to trial court theories by the appellate tribunal does not mean that no new position may be taken or that new arguments may not be adduced. All it means is that the substantive questions, independent in character and not within the issues or not presented to the trial court, shall not be first made upon appeal. Questions within those issues are before the appellate court, and you can talk about new arguments or new authorities within those issues. And it said a crucial factor is whether the opposing party had an unequivocal notice of the existence of the issue and an opportunity to defend against it. Well, in this case, this is how the court applied that rule in this case, because you had the arguments about the 6-year statute of limitations below, and the Uniform Commercial Code statute the court relied on is also a 6-year statute of limitations. So, Ali knew about this 6-year timeliness argument, and then what it said about this notice and opportunity to argue, it said he had notice of the timing issue in the trial court and had notice and an opportunity to defend against both statutes on appeal. So when you're looking at this waiver, the court's, I would say, narrowing the scope of cases in which a waiver applies. If you are arguing something within the kinds of general framework you argued before, and you make sure that the opposing party has a chance to respond to you on appeal, then according to this rule, there shouldn't be a waiver. And I thought that was a significant clarification of the waiver rules and something you should look for if you're dealing with appellate issues in the near future. The next case I'm going to talk about is yet another case from the Indiana Supreme Court. That's what happens when March gets canceled, is we have lots of Indiana Supreme Court cases. It's Burton versus Benner, and it deals with Indiana's Tort Claims Act and when government employees are going to be immune, or when they may be not immune because they acted clearly outside the scope of their employment. And this is the fact pattern. In 2015, you had Benner, who was a state trooper, and he drove an unmarked car, which was called a commission. Now, the state police have a variety of guidelines around what troopers can do with these commissions. And among other things, they're required to maintain radio contact at all times, obey traffic laws, and respond to emergencies, even when they're off duty. And then it also allows them to use their commissions for, somebody is, and it's creating a lot of feedback. And then this personal use. So in 2015, what Benner did is he used his commission to drive to his son's baseball game. And he was behind another car on the road, and he decided to pass it. And as he passed it, he realized there was a motorcycle coming the other way. So he slowed down to get back in the lane, but it was too late for that motorcycle driver, who was Burton, and Burton locked up his brakes, slid, and was injured. And so Burton sued Benner, saying that he should be personally liable for doing a lane change when it wasn't safe. And the Benner argued he was immune from suit because he wasn't clearly outside the scope of his employment, and the trial court granted that motion. And then the Court of Appeals reversed, finding there's a genuine issue of fact on the question. It goes up to the Supreme Court. The Supreme Court says, well, it's not whether the question in these types of cases isn't whether he was actually inside or outside the scope of his employment. It was whether he was clearly outside the scope of his employment. And when you have that clearly be part of what you're trying to find, the court called that a high bar. And it said in this case, the trooper, he was compliant with vast majority of the state police procedures. And what he was doing was of the same general conduct and same nature of what was authorized. And indeed, he had the radio on, he was on the road. If he's on the road, it's actually helpful to the police because he can respond to emergencies if necessary. And the argument that Burton tried making in response is that, well, he wasn't in compliance with these rules because he was speeding. He was going somewhere between 62 and 65 and a 55 when the accident occurred. And the court said, that is a minor violation of the rules and guidelines. And we aren't going to say that government employees are clearly outside of the scope of their employment when they have minor violations like that. And so this high bar is going to be one that's going to be, I think, difficult for plaintiffs to meet in many, many cases. And it's something to think about if you're involved in that kind of litigation. Ron?
We're going to turn next to a Court of Appeals case. It's one of particular interest to anyone who has to deal with a situation in which you've got a claim against an entity that ceases to exist, but the business continues in a new name with a new entity. The question is, can you sue the new entity that's continuing the business? And the issue arose in this context. This is the case of New Nello Operating Company, LLC versus Compress Air. First, you have a company that is referred to in the opinion as Old Nello, that was created in 2002 by a fellow named Dan Iannello, and others who were in significant management positions were Lambert and Rumpler and Brisson. And they continued in business for a number of years. In 2016, they ran into financial problems, and that entity got sued by by Compress Air. They had installed some piping in a building of Old Nello's, and so they sued for the balance, and they ended up getting a judgment against Old Nello for what was owed. And And then, since old Nello no longer had the business, new Nello had taken over the business. They sought, by a proceeding supplemental, naming new Nello as a garnishee defendant, and sought to establish liability against new Nello under a theory that this was a de facto merger. And so when this came up to the Court of Appeals, the Court of Appeals looked at the factors associated with this de facto merger doctrine, and where the economic effect of the transaction makes it a merger in ultimate name, it will be applied. And they identified, and you see them on the middle of page 10 of your handout, they look at several factors, one of which is the continuity of ownership. Now, in this case, there was not much, if any, continuity of ownership that can be discerned, but there was continuity of management, personnel, and physical operation. The business did not secede. The cessation of the ordinary business and dissolution of the predecessor as soon as practically and legally possible. In this, there wasn't, in fact, a dissolution of the predecessor, but it ceased doing business. An assumption by the successor of the liabilities ordinarily necessary for the uninterrupted continuation of the business of the predecessor. There was some of that. There was also using the same website, making no public announcement that there was any change, not either to the general public or to their own employees, any change in the company. They held themselves out as Nello and claimed to continue to have been founded in 2002. Under these circumstances, the court, both the trial court and the Court of Appeals says these facts are sufficient to support a de facto merger, and by a methodology of a garnishee defendant under proceeding supplemental can be held liable. So it is helpful for those who are dealing with issues where one entity is replaced by another and continuing the business. It also makes clear with respect to proceeding supplemental, when you receive findings of fact and conclusions of law in a proceeding supplemental, they're not required, as indicated in these lessons. But if that's what the trial court does, then the standard of review on appeal will be one that applies to findings and conclusions. And of course, it is clear from these facts that a change in ownership will not preclude the finding of a de facto merger. What you ought to do, as suggested in the final lesson there, is take steps to clarify that it is a new company under new management if you want to seek to avoid the debts of the predecessor business. Our next case also comes from the Court of Appeals, an opinion by Judge Crone on the duty of good faith and fair dealing, and asks this question, or addresses this question. It's certainly well established that policyholders of insurance policies have a right to be dealt with in good faith and fair dealing by the insurer. But the plaintiff in this case was not a policyholder, but was an insured. She was a passenger in a car. The car was struck by another car, so she's got defendants that include the car in which she was a passenger, the driver, and the driver of the other vehicle. And there were issues about underinsurance, motorist coverage, and whether Schmidt qualified as an insured. No, she did qualify as an insured under Fisher's policy. And so Allstate, as the insurer for Fisher, recognized that she was an insured, but denied that there was any obligation to handle her claim in good faith and fair dealing, argued that a bad faith claim is not available under Indiana law for an insured who is not a policyholder. The Court of Appeals, in an opinion by Judge Crone, determines that there's very little difference in its opinion between insureds who are not policyholders and those who are. And it looks to statute, the Unfair Claims Practices Act, which treats insureds in the same way as policyholders. It draws no distinction, and it looks to public policy. And it summed up its opinion. It said, with apologies to Gertrude Stein, an insured is an insured is an insured. is an insured for purposes of an insurer's duty of good faith and fair dealing. So that's at least now established by the Indiana Court of Appeals. Whether the Supreme Court will reach the same conclusion, we'll have to see whether they will even accept transfer in this case. So with that, we'll move it back to Brad.
The next case I'm going to talk about is Kavanaugh's Sports Bar and Eatery versus Porterfield. And you may recall in 2016, the Indiana Supreme Court restated what the law is in Indiana on assessing foreseeability in the context of determining whether there's a duty. And it appears that the court didn't like the tack that the Indiana Court of Appeals was taking on those cases and decided to clarify what it meant in this Porterfield case. And the situation you had was that Porterfield had been out with some friends one night and ended up at this bar called Kavanaugh's. He and his friend didn't have any disputes with anybody at the bar, and it was closing time, and everybody went out to the parking lot. And out in the parking lot, a fight ensued, resulting in severe injuries for Porterfield. I believe he was blinded in at least one eye. He sued the bar for negligence, and the bar moved for summary judgment, arguing it didn't owe him any duty because there was an unforeseen criminal act. The trial court denied the motion for summary judgment. The Court of Appeals affirmed that decision, and then it went up on appeal to on transfer to the Indiana Supreme Court. And the court reaffirmed its earlier holding and emphasized again that when you're talking about foreseeability in this context of a duty, you've got to evaluate the broad type of plaintiff and the harm involved with regard to the facts of the actual occurrence. And then it said a key factor in this kind of determination is if the landowner had reason to know of any imminent harm, because if so, then that harm was foreseeable in the duty context. Now, when saying that, the court said that concurrent knowledge of imminent harm is sufficient but not necessary. And then it said that in this case, that the bar had no notice of present and specific circumstances that would cause it to recognize the risk of an imminent criminal act. Now, Porterfield had, in response to that kind of thing, he had given lots of evidence showing that in the past few years, the police runs had come to the bar numerous times for rowdy behavior and quarrels and things like that. But the court said that that kind of evidence is fine when you're looking at foreseeability in the light of probable cause, but it's not the kind of thing that you can look at in the context of a duty. And so in this case, then you had no evidence that the bar had any idea that a fight was about to occur at that particular time. And so therefore, there was no duty to protect Porterfield from that fight. Now, there was a dissent that was signed by Justices Goff and David, and they dissented for a couple of reasons. And I think this is going to be things that people are going to be paying attention to when they're briefing this kind of thing in the future. First, the justices thought that the majority added new requirements to the foreseeability injury. Because while the court said, on one hand, you don't need evidence of contemporaneous evidence of imminent harm, in its analysis, it then backed away from that and looked at whether there was any contemporaneous evidence. And then second, these justices felt that the majority incorrectly focused on the particular facts of the case, rather than looking at the broad type of harm, and it looked at the specifics of this particular case. And the dissent, what it said was basically that we are afraid that the majority is excluding the possibility of harms that are not always imminent, and that when you have harms that aren't imminent, that they still may be foreseeable, and it was worried that the majority is slipping away from recognizing that as possible. Finally, they thought that this would lead to a lot more summary judgment findings in close cases in these kinds of premises liability cases. And so I think that both plaintiffs and defendants are going to be paying a great deal of attention to that dissent, in addition to the majority when trying to figure out how they're going to apply Kavanaugh in the future. The next case is yet another case from the Indiana Supreme Court. This one written by Justice David. It's In Re MS, and it deals with the particulars of Chin's proceedings, but basically the interaction between rules and statutes more broadly. And in this case, you had a Chin's proceeding that was started, and there's a statute that says that when you start a Chin's proceeding, that the fact finding needs to be done within 60 days. Now, it does say that this deadline can be waived by the parents, and the statute says in that event, the fact finding shall be completed within 120 days. Well, in this case, you had a Chin's petition that was filed. Both parents waived the 60-day deadline, and fact finding was continued. But then during that time, the mother requested discovery, and then you had a motion to quash filed, and then the mother requested a continuance to address the discovery dispute. A fact finding took place a little while later, but mother introduced 2,000 video clips, and the court said, you got to cut this down for me so I can understand what's important and what's not. Well, that didn't happen for a month later, and eventually it took another 6 months after that for the court to adjudicate the Chin's proceeding, and another month after that to enter a dispositional order, so well over the 120-day period. Well, the mother moved to dismiss the Chin's proceeding because the fact finding wasn't completed within that 120-day time frame. Trial court denied that motion, went up on appeal, and the Court of Appeals reversed, saying that statute has a bright line rule. We got to file the bright line rule. The court granted transfer, and it said, yeah, that statute has a bright line rule. But that rule is procedural rather than substantive, because it talks about the mechanisms for extending time within the court proceeding. And it said when it comes to those kinds of procedural rules, the trial rules trump statutes. And in this case, you have Trial Rule 53.5, which says a trial court can continue deadlines for good cause. And said in this case, that's what applies. Even though the statute says shall, as long as there's good cause shown, well, you can continue those deadlines. And in this case, there was good cause shown because you had the discovery dispute that needed to be resolved, and you had these other issues with the videos and things like that needed to be resolved. The one thing the court said is that it doesn't want trial courts to extend these deadlines too freely, and that this should be done few and far between. And basically, what the court is instructing trial courts and frankly us to bring it to the trial court's attention is to create a clear record that there's good cause shown, maybe even have a hearing to establish that. Well, you can't do it in a 120-day time period. So this is not the kind of thing that the Indiana Supreme Court says you file a motion saying you're busy and you need more time. This is something that really, really needs to be done, and you really have to show good cause. It'll be interesting to see how that body of law develops over time. The last case I'll talk about before I kick it back to Ron is a case from the Indiana Court of Appeals from Judge Vedic. It's Paternity of CB versus Davis. And it is interesting to note, I learned something about attorney's fees and fee shifting in this case. You had a mother and a father who had two children, but they weren't married. The mother and father weren't married.
Brad, you want to shift the slide?
Oh yeah, sorry about that. You forget about those things when you're the speaker on Zoom. So father's paternity was established, and he gets they go to the court arguing about custody and parenting time. Mother was awarded sole legal and primary physical custody of the children. Father got parenting time, and father had to pay mother's attorney's fees. Well, father appeals. Mother asks for appellate attorney's fees while the appeal is pending. Trial court doesn't rule on it right away. While the first appeal is pending, father files a second appeal. Again, mother asks for appellate attorney's fees, and again, the trial court doesn't rule on that right away. Instead, the appeal ends, both appeals eventually end, and the trial court holds a hearing on mother's request for these appellate attorney's fees. And at that hearing, the mother's attorney submits evidence of about $39,000 in attorney's fees. Now, before the trial court rules on this motion, mother and attorney have a falling out, and she fires the attorney. The attorney withdraws. Mother withdraws her request for fee shifting. And then the attorney moves to intervene, saying, no, 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 I need those fees. The trial court grants the motion, gives the mother's attorney all the fees she was asking for, and father appeals. And the court looked at whether the attorney had an independent right to seek these fees from the father. And there's a statute that says that attorneys may enforce attorney fee orders in their own name, but that statute doesn't give attorneys the right to request attorneys' fees in their own name. And it said that that's a big difference here. And that in this case, the trial court hadn't granted any of those appellate attorneys' fees. Instead, only a motion had been filed. And the attorney doesn't have a right, separate and apart from the mother, to request those attorney's fees from the father. And since there was no order in place awarding the fees in the attorney's name, well, then, she's out of luck trying to get those fees from the father. Now, the court did say she can try to get them from the mother, but obviously the attorney was unhappy with that to start with, and maybe out of luck in getting those fees that she otherwise would have been entitled to. Ron?
Our next case is also in the Court of Appeals. This one by Judge Mathias, Shield Global Partners, G1 LLC versus Forster. And it's a vehicle property damage case. And ordinarily that doesn't sound like it would involve a very significant issue, but it does. And the issue is a claimant who gets his car fully repaired, or vehicle fully repaired, is he entitled to additional damages associated with the diminished value of the vehicle under the law? And it arises out of a rear end collision. A truck is damaged. The truck is repaired for $1,600. But the Blue Book value after the repair goes down by $4,000 from $36,500 to $32,500. And they had an appraiser say that the inherent diminished value is $7,400. It's repaired. It works fine. Its market value, however, has diminished. The trial court addressed this issue and determined that the diminished value part was unrecoverable since the vehicle was fully repaired. But on appeal, the Court of Appeals takes a different view, that no, the damages for diminished value should be available on top and are available on top of the repair value. And in support of that, they point to the fact that this comports with economic reality. If you look at Carfax, it allows anyone to check to see if an automobile has been involved in an accident. So you can find on Carfax, and you can see on Blue Book, if it's involved in an accident, it's worth $4,000 less than if it's not involved in an accident. So they say that's a recoverable claim on a property damage case, and that is now Indiana law. And even if it's fully repaired, if there's diminished value, that is an additional damage that is available with respect to such claims. Our next case, we go back to the Indiana Supreme Court in a decision by Justice Massa that addresses a wrongful termination case. A wrongful termination case brought by a former employee of Memorial Hospital of South Bend. Mr. Perkins actually had worked for 32 years as a Michigan State trooper, went to work in the police department or office of the hospital. He was an at-will employee. He'd been working there about 4 years when one of his coworkers was injured, and there was an unemployment hearing for unemployment benefits. And he went to testify on behalf of this co-employee. He went he was told that a subpoena would be waiting for him at the hearing, and that Bradley's counsel, the co-workers counsel, had requested a subpoena. So since the subpoena was there waiting, being a cooperative guy, he went to the hearing and asked for the subpoena, and the hearing officer said it wasn't needed, didn't give him one, but asked him to testify. So not long after this hearing, Mr. Perkins fired. And the reason for firing, according to the hospital, was not because he had appeared at this hearing, but because he had no prior disciplinary issues, 32 years apparently successful as a state police trooper in Michigan, but he gets fired because he ladled gravy over his biscuit without paying for it in the hospital cafeteria. Now, Mr. Perkins suspects that it may have had more to do with his testifying against the company in the unemployment hearing, and sues for wrongful termination, and claims the public policy exception for his testifying at this unemployment hearing. And there is a public policy exception that clearly established that if you were under a paper subpoena, you would fit. But he didn't get the subpoena. And so the issue presented to the Indiana Supreme Court was, well, is he going to be protected by the public policy exception or not? Well, 4 members of the court believe that he was protected, and that it dealt in part with the special circumstances of this and another obligation of citizens. And the special circumstances were these. So were the ones I went through a moment ago. He had been told that a subpoena was waiting for him, and so he went to the hearing for it, requested it, and then the administrative law judge says it's not necessary. And the court says, well, trial 4.16 requires, and I'm going to quote it because this was not something that was familiar to me, it shall be the duty of every person served under these rules to cooperate, accept service, and then continues. There's a rule of cooperating with subpoenas. And so he had that duty of cooperation, and the majority basically says, in light of that duty to cooperate, and in light of these circumstances, this fits the public policy exception in our view. Now, and so wrongful termination is an available remedy to Mr. Perkins under these circumstances. But Justice Slaughter wants his bright line test. And he says, well, he understands that a witness has a duty to cooperate and accept service, but that duty is modest in his view. It forbids the witness from evading service, but does not require the witness to take affirmative steps to track down the process server. No one served or tried to serve Perkins with a subpoena, but he was told a subpoena would be waiting for him. The court basically says, you can't fire an employee, an at-will employee, for complying with a legal duty. You can't fire an employee who appears in an employment hearing under the belief that a subpoena will be given to him. And the court is not going to blame witnesses for technical or procedural defects in a hearing officer's order. So interesting case. Public policy protects Mr. Perkins. With that, I'll turn it back to Brad.
The next case I'm going to talk about is another case from the Indiana Supreme Court, this one written by Justice David, American Consulting, Inc. versus Hannum, Wagle, and Klein Engineering, Inc. This is a case involving non-competes and non-solicitations and liquidated damages. And what you had is you had Knowles, Day, and Lancet, who were in sales for ASI. And they each had covenants as part of their agreements to work there. Knowles, who was the more senior person, had a covenant not to compete and a covenant not to solicit. If he solicited, he'd have to pay 50% of the pay of the employee he solicited. The Day and Lancet each had non-solicitation clauses, and they'd have to pay 100% of the pay of the person that they solicited. Knowles eventually left ASI, went to go work at a competitor, and Day and Lancet both joined him. They then proceeded to compete and recruit people and solicit employees. And so ASI sued. The defendants argued that this liquidated damages clauses were unenforceable because they were really penalties, not liquidated damages, and the trial court agreed. The Court of Appeals reversed, and then it went up to the Supreme Court on transfer. And on transfer, the court said that we need to clarify a difference between liquidated damages and unenforceable penalties. And in this case, the penalties were unenforceable because they could amount to hundreds of thousands of dollars for the non-solicitation clauses and millions for the non-compete clauses. And what the court said is that liquidated damages are, if they're going to be related to non-solicitation clauses, they're facially problematic here because there's no indication. ASI didn't give any proof of how an employee's salary in 1 year correlates to the loss for the company if they lose that particular employee. And the court said that there's also no explanation for why Knowles, the person who is higher in the organization, is responsible for 50%, and a Day and Lancet are responsible for 100% of that employee's salary that's solicited. Moreover, if you have Knowles, Day, and Lancet all together, you have 250% of that employee's salary. And the court said, even if we were to assume that lost salary was an appropriate measure of damages, there's no explanation for why 250% of the lost salary should be the damages in this case. It distinguished these kinds of percentage-based damages from liquidated damages that it had approved in the past, noting that those were sums that were a specific sum certain, rather than tied to a percentage of a sum to be ascertained in the future. That the percentages in this case weren't tied to actual lost revenue, unlike the specific sums that it had approved in the past, and that the damages here aren't just limited to a portion of defendant salaries. Indeed, they far exceeded the salaries of these individual defendants. Moreover, the court was bothered by the fact that the penalties here applied the same punishment for a broad range of conduct. Just unsuccessfully soliciting an employee had the same penalty as successfully soliciting that employee, and that's a punishment that's meant to secure that these penalties are meant to punish the breaching party, not merely secure performance with the contract. Now, the court said that ASI could have overcome these issues if it could have tied those liquidated damages and those percentages to the value of the employee, but it said it just did not do so. Now, there was a dissent by Justices Slaughter and Massa, and it came down to two things. They felt that the employee, not the employer, should have the duty of proving that the liquidated damages are unenforceable penalties, and therefore the employee needs to show and prove that there's no correlation between the liquidated damages and the actual damages. They felt that the court went the other way by putting it on the employer, the responsibility of proving that, and they characterized this as a new benchmark for applying what we have called our heightened summary judgment standard, and so they didn't like that result at all, and the way that the court assigned the burdens in these kinds of cases. So if you're dealing with these kinds of cases, I think this is going to be an important case for you to look at, if nothing else, for that question of who has the burden of proof. The final case I'll talk about today is from the Court of Appeals. It's Sartain versus Trilogy Healthcare of Hamilton 2, and it deals with a question of procedure that I hope we don't fall into. In this case, you had Sartain file a 4-count lawsuit. Counts 1 and 3 were dismissed for failure to exhaust administrative remedies. Litigation continues on the other 2 counts, and eventually there's a settlement. And the parties filed a stipulation of dismissal with the trial court, a proposed order that dismissed the case in its entirety. The court signed that order, and then Sartain appealed the dismissal of counts 1 and 3 previously. The panel initially denied a motion to dismiss the appeal, but they went to the motions panel. They went to the writing panel, who revisited the question and agreed this was not a proper appeal. It said, when you look at trial rule 41A1B, it says that a stipulation of dismissal is effective without order of a court. That means that when you file a stipulation of dismissal, having an order that you're filing with it is basically a nullity. It doesn't do anything. That the case ends with the filing of the stipulation of dismissal. And therefore, you don't have a final judgment or order of a court to appeal from. And so if you are settling a case and the parties are contemplating there's going to be appeal of an issue, you can't be filing a stipulation of dismissal, because that just ends the case. There's no way to appeal from there. And it said, it gave a contrast of this with another case previously, Keck versus Walker. And I'll let you read that for yourself. But basically the idea is that make sure you plan, if you're planning on appeal, and get that in the dismissal paperwork so you don't freeze yourself out. Ron?
Thank you, Brad. Our last case comes from Court of Appeals, an opinion by Chief Judge Bradford. It's the case of K.R. Calvert Company versus Sandys, and I'll be brief since our time is short. Basically, you will see in this case guidance for the proper practice of litigation. What you find referred to in this case first is a failure by a party to file an answer to a complaint, and a failure by its counsel to, even after being notified by email that the case is filed and they haven't answered in a timely way, who still disregards and ignores it, and then argues both to the trial court and on appeal that this was excusable neglect, and the court rejects the notion and affirms the default judgment that is entered under these circumstances. The court also looks at the trial court and the Court of Appeals, look at a course of behavior by this party and this counsel in terms of filing motions that the court regards as inappropriate and unwarranted, including numerous motions for extensions of time, refusing to provide discovery in response to discovery. It is a litany of litigation failures on a party. That party ends up getting, not only losing on all counts, but also being ordered to pay $106,000 in attorney's fees to the opposing party. And the individual attorney also gets another $1,200 for filing a motion requiring a defense that the court regards as inappropriate and improper given the issues in the case. I advise you to look at it not only from the perspective of avoiding it, but also if you encounter lawyers like this or litigants like this, it provides some ammunition about how to deal with that kind of practice. And let me end with, as I usually do, an advocacy tip of the month. And I've got, this also comes from the ABA Journal, and I've titled this simply Learning from COVID-19. And what you see there, and I'm not going to go into detail except to say, it suggests that the telecommunicating debate is over, that through this experience, we've learned that remote working conditions do work. And we can be productive. And that's certainly been my experience, and I think our law firm's experience. And it says, secondly, the FaceTime myth is exposed, the notion that you get more from gathering at the proverbial water cooler or the lunchroom. With Zoom like this and others, we do have face-to-face contact, if not in person, that helps to alleviate any such concerns. It also suggests that the necessity of business travel will be challenged. And that because we can do depositions and we can do hearings and other things now remotely and meetings with clients, we don't need as much business travel. And it also suggests that we've learned that the team approach is being recognized for its true value as we work together in these Zoom meetings or otherwise, and actually may in fact be talking more with one another than we do if we're passing one another in a hallway in a law firm. And then the final tip from Ms. Blakely was to embrace the new technologies, the one that we're using today, because not only for all the reasons that were stated, but because the younger generation is going to do it and expect it from those of us who are older. I also give you on the last page a quote from John Trimble, published in the Indiana Lawyer, and I would simply recommend that to you as it reflects in part the value of our law club, because he observes that if we've learned anything from this experience, we have learned that a life in law is far, far more than money, fame, or success in a courtroom. It is ultimately about relationships. We realize once again that the greatest gift of what we do is the friendships we've been able to acquire along the way. And I appreciate all the friends in the law club. I'm sorry we're not there in person, but I'm glad we were able to do this remotely, and look forward to seeing you in person or remotely in our meetings in the future. Thank you all.